Welcome to Ask a Property Manager, episode 101. This is our first episode in 2022, and today we're going to be taking a look at good cause eviction here in the state of New York and what that might mean if this legislation is passed. You're going to want to stick around to the end of this video because there are two pieces of information that you need to know about. Two pieces of legislation that were slipped into this bill that will leave you exposed as a landlord if you're not aware of them. We're going to go ahead and jump into all that right after this. So I was tipped off to this by an email from the New York State Capital Region Apartment Association. And we're talking about this today because there's been a good cause eviction bill here in the state of New York pending since last January. And actually, it's been pending in years previous as well. This is one of those bills that's rolled over time and time again. However, we're coming up on the end of our eviction moratorium here in New York State. Our eviction moratorium is scheduled to expire January 15th, 2022. As I'm recording this, it is January 5th, 2022, so we're talking about 10 days. We don't have a lot of time here, and essentially what's happening is lawmakers are meeting on this bill right now in an attempt to get it pushed through before January 7th, prior to this eviction moratorium expiring. The Senate bill is S-3082. The Assembly bill is A-5573 if you want to Google those up. I'm going to go ahead and pull it up on the desktop here real quick. This is the Senate's version of the bill, and you can see the full text. Guys, this is only a 4-page bill. 1, 2, 3, 4. And there's a lot of information packed into those 4 pages. My recommendation is if you haven't had an opportunity to take a look at this bill already, do a little bit of time, do a little bit of research, spend a little bit of time reading this. It's 4 pages. It'll probably take you a few minutes to read through it, but there's quite a bit of information to unpack in here. What we're going to do is break this down into 3 different pieces. We're going to be talking about what is a good cause eviction, who does this legislation apply to, and what's considered a good cause eviction. What are the categories? We're also going to talk briefly on how you can help stop something like this, but we are going to go ahead and jump right in here with what is a good cause eviction. Very simply put, a good cause eviction means that the landlord can only terminate the tenancy via eviction for good cause. The landlord will not be able to terminate the tenancy at the end of the lease term any longer. But essentially, it's a forced renewal of that lease term, whether it be a 1-year lease or a month-to-month tenancy or whatever the case may be. Essentially, they're taking away the landlord's ability to say, we no longer wish to rent to you at the end of this lease term, please move. You're basically forced into a situation where you now have to continue to rent to this person once they have established themselves in this unit. So the way to get out of this would be through the good cause eviction procedure. We're going to touch on the 8 categories here in just a minute. But first I want to talk about who does this actually apply to. So good cause eviction applies to all housing providers in the state of New York except for, and there's 4 carve out here, but I think most of the people who will qualify for these carve outs are going to fall into this first category, which is owner-occupied properties of fewer than 4 units, 1, 2, or 3 units. The law actually says fewer than 4. It doesn't say 4 or fewer. So if you are operating in a 4 unit, but it is an owner-occupied property, this still applies to you, the way I read it. Guys, I'm not an attorney. I probably should have mentioned that at the start of this. I am not an attorney, and you should certainly be speaking with your attorney on this as well. Obviously, don't make any decisions based off of what you hear on the internet. Talk to your legal team and understand what it is that you're doing before you start trying to pursue an eviction on someone. Going back to our who does this apply to section, the second group that this does not apply to would be an apartment sublet where the person who subleased the apartment is moving back into the apartment. So essentially, if you sublease an apartment because you have to move for 6 months for work and you come back, you can ask that tenant to leave the apartment. You have an exemption there. You can get out of the good cause eviction rules and just terminate that tenancy. The third category would be if you have employment that guarantees your housing as part of your employment. For instance, maybe you work for a property management company, and one of the perks of your job is they include an apartment for you to live in as part of your compensation package. If they fire you, they can revoke your housing at that time as well. And last but not least would be units that are already subject to good cause eviction, which might be units that are subject to rental regulation or subsidized or in certain federal programs, whatever the case may be. Those units, chances are, if you know that you can't do a good cause or you have to evict for good cause, chances are you already know you're in that category. So, okay, we've talked about who's responsible, who this applies to. We've talked about what a good cause eviction is and what it means for housing providers. What are the actual categories here? There's a total of 8 categories for good cause eviction. We're going to go through and knock them all out, and then you'll have an idea as to what are your outs when it comes time to terminate a tenancy if you're in a situation where you have a non-cooperative tenant or whatever the case may be. First and foremost is failure to pay rent. If a tenant doesn't pay their rent, you can move forward with an eviction. That's considered a good cause. I think that everybody's kind of on the same page there. Lease violation longer than 10 days after written notice is served. This one I found interesting because previously I don't know of any piece of legislation that actually put a number of days to how long you had to cure a lease violation. And that seems to have appeared in this piece of legislation. Again, I'm not an attorney, I could be wrong, but I did not know of any set number of days prior to seeing it in this piece of legislation. Third category, nuisance tenant, malicious damage, negligent damage, or disturbing the quiet enjoyment of the property. This is going to be a very difficult category to get an eviction awarded on. We've been trying throughout the pandemic to get some evictions awarded based on nuisance tenants, based on malicious damage, based on tenants operating basically drug sale, they're running drugs through these properties. And we've yet to get a nuisance eviction awarded to us. So that category is going to be a very, very big challenge. If you think that's going to be the category you use to get rid of a bad tenant, it's going to be a challenge. Category 4, tenancy causes landlord to be in violation of law subject to criminal or civil penalty, or if the building is condemned. So if you have a tenant that's causing building code violations, and it reaches the point where you're now subject to a penalty, some sort of a criminal or civil penalty, beyond just a simple fine from the building department, is kind of the way I'm reading this. Or if it's so bad that the building has to be condemned, you do not have to, that's considered good cause at that point. Category number 5, tenant is using the unit for an illegal purpose. I think that's pretty self-explanatory. Number 6, tenant unreasonably refuses access to the landlord to make repairs, complete inspections, etc., etc. That's an interesting one because I know here in the state of New York, we do have to give 24 hours notice prior to entry. If you refused notice after that if you refused entry after that 24 hours, you may be in a situation where by documenting that happening enough times and a tenant's failure to allow you in to complete repairs or do an inspection or do what it is that you need to do at the property, you may be able to remove that tenant based on that. Next category, building has fewer than 12 units, so 1 to 11 units, and the landlord wants to use the unit for himself, herself, or an immediate family member when no other units are available in the building, and you can only do this for 1 unit. So if you have a 1 to 11 unit building, and you want to use the unit for either yourself or an immediate family member, and there's no other units available in that building, you can reclaim 1 unit to do that. If you have fewer than 5 units, so this would be a 1 to 4 unit building, and you as the landlord want to use the unit, and this is the final category, for yourself as a primary residence, so under 5 doors, and you want to use it personally as a residence, you can evict all of the units. So if you bought a 4-unit building and wanted to convert that entire building to a single family, the way I look at this, that would be a reasonable reason, I guess, a reasonable justification, the way that the law is written in its current form, or the way that the legislation is proposed in its current form, I should say. So there were a couple of other interesting points that came out of this legislation. There were 2 things that I noticed that were problematic to me that I wanted to make sure that landlords knew about, because these could leave you exposed if you're not paying attention to this legislation. The first point relates directly back to the point we just talked about, and that would be the building with 12 or fewer units, or the unit with 5 or fewer units, where essentially a landlord is attempting to take over a unit to place themselves or a family member in that unit. If you use that justification and you lie about it, it leaves you open to a lawsuit from the tenant. The tenant can come back and sue you for removing them for the unit without just cause, or without good cause. And then the other interesting point that I found in here was there's a carve out in here for what is considered to be an unreasonable rent increase. And it's any increase of more than 3% from one year to another, or more than 1.5% the annual percentage change in the consumer price index. And that gets released every year in August. So if you remember, New York State does have legislation already passed that limits the amount that you can raise rent. It doesn't limit the amount you can raise rent. It limits the amount of notice you have to give before raising rent more than, I believe it's 5%. In this legislation, they specifically state that any increase of more than 3% year over year, or more than a 1.5 times the annual percentage change in the consumer price index, if either one of those criteria are met, that would be considered an unreasonable rent increase in New York State. I don't know what that'll mean in the long term. I don't know how often that'll get pointed at as, well, you can't actually increase the rent as much as you want because blah, 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 blah. Or you increase the rent by 5% instead of 3%. That extra 2% of rent, that's considered unreasonable. We're not going to pay that out. So last but not least, I do want to talk for a quick second here on how you can help. And the best way that you can help is by being involved. Contact your senator, contact your assemblymen, and let them know that you do not stand behind good cause eviction. You want to be able to run your property, you want to be able to run your business the way that you see fit. The other thing that you should be looking at is join groups like NYCRA, join groups like Western New York Real Estate Investors Association. Join these groups that help you stay involved and help you stay informed. Attend the meetings regularly, pay attention to the online discussions, and understand the business model that you're operating as well as what's happening in your industry. Thank you all so much for watching. I hope that your 2022 is starting off right. If you like this, do me a favor and share it. Questions or comments, drop them below. We'll talk to you soon.